Over the last few weeks, Diddy's defense lawyers and the U.S. attorneys have filed several motions. But today, the U.S. attorneys dropped some bombs on Diddy in response. So I'm struggling to find the PDF document of the first motion they filed, but here's a little quick summary. Sean Diddy Combs' legal team accuses the U.S. government of leaking information, including a 2016 video of him physically assaulting Cassie Ventura, which they say biased the public against the music mogul. Bias the public? I mean, I know they're probably thinking about a jury here, but come the fuck on. That's just laughable. In a letter supporting their motion for an evidentiary hearing filed in the U.S. Court for the Southern District of New York, Combs' lawyers asked the judge for 4 forms of relief related to what the defense believes was a series of unlawful government leaks, which have led to damaging, highly prejudicial pretrial publicity that can only taint the jury pool and deprive Mr. Combs of his right to a fair trial. I've learned so much of the YSL trial, I knew they were already thinking about the jury, hearing all the negative publicity about all this, but come on now, man. It's so stupid. I know that's actually a real concern for them. It's going to be hard to find a jury that doesn't know anything about this case, but his lawyers Mark Agnifilo and Tinny Durajos say there should be a hearing to investigate alleged government misconduct and for government agencies, including Homeland Security investigations, which led the raids on Combs' homes in the March that are involved in the case to reveal communications and records related to alleged leaks to media outlets. I mean, it just sounds like they're kind of grasping at straws here, to be honest. I don't think there's going to be a hearing to investigate this government misconduct, sadly. For Diddy there, he has his hopes up, but further they asked the judge to issue an order prohibiting federal employees from disclosing evidence to news media as well as the suppression of any evidence leaked by government employees. So do they have evidence of this, or are they just literally guessing at what happened here? This has raised public hostility against Mr. Combs in advance of trial. That, just the video of Cassie, I mean, it's damning evidence for sure. Maybe you shouldn't have beat your girlfriend, dumbass. Holy shit. Like, what the fuck are we doing here? We're upset about the public seeing a video of me beating my girlfriend in a hallway of a hotel. Complete moron. Combs kicking and hitting and dragging ex-girlfriend to the elevator of a hotel. Apologized for his inexcusable behavior. His lawyers have painted the abuse as the result of a toxic relationship rather than evidence of sex trafficking. Prosecutors claim the video was Cassie fleeing from his freak-offs. Diddy's team claims Cassie received an 8-figure settlement and likely didn't leak the video. 8-figure settlement? That means $10 million plus. Holy shit. Wow. That's wild. The reason a hearing is needed is to determine exactly what the DHS did and did do not regarding these leaks and what the U.S. Attorney's Office did and did not do to stop them. So they're saying the U.S. Attorney's Office knew and did that on purpose. I mean, I know there's probably some corrupt shit on both sides, but probably reaching here. Gives several examples of unnamed sources quoted in various news stories about the criminal investigation, and claims DHS agents issued this information. Between the grand jury leaks and the incendiary public statements, the agents all but ensured that the grand jury would be tainted as well as the general public, from which we will soon select a jury. All right, Diddy. All right, here's the next motion that Diddy's team filed. This motion pertains to disclosing victims' names. 60% of you aren't subscribed. Come on, hit the subscribe bell. All right, they started by saying this case is unique, in part because of the number of individuals levying allegations against Mr. Combs due to his celebrity status, wealth, and the publicity of his previously settled lawsuit, and the grand jury leaks and false inflammatory statements by the DHS agents, as outlined in our previous motion. This has had a ripple effect resulting in a torrent of allegations by unidentified complainants spanning from false to outright absurd. Yesterday alone, anonymous accusers filed an additional 6 lawsuits. Counsel for these accusers recently convened a press conference at which he claimed to represent 120 accusers making outrageous and deeply prejudicial allegations. The stuff about kids that, you know, the worst thing you can possibly think of. This publicity stunt broadcast on Instagram included a 1-800 number that reportedly received 12,000 calls in the first 24 hours. These accusations came on the heels of more than a dozen lawsuits previously filed and currently pending, several of which have been already discredited, but only after damaging Mr. Combs' character and reputation. These swirling allegations have created a hysterical media circus that, if left unchecked, will irreparably deprive Mr. Combs of a fair trial. On October 7, 2024, Mr. Combs asked the government to identify its alleged victims. Counsel has conferred with the government, who opposes disclosure of alleged victims' names at this stage. So they're citing United States versus Davidoff to identify with sufficient particularity the nature of the charge pending against him, thereby enabling defendant to prepare for trial to prevent surprise and to interpose a plea of double jeopardy should he be prosecuted a second time for the same offense. So they're saying they need to prepare for trial. With the wide latitude accorded the prosecution to frame a charge that a defendant has conspired to promote the affairs of an enterprise through a pattern of racketeering activity, comes an obligation to particularize the nature of the charge charged to a degree that might not be necessary in the prosecution of crimes of more limited scope. The circuit held in David off that where the government failed to identify the victims of uncharged schemes that intended to include a trial, the district court committed reversible error by failing to grant a bill of the particulars. Indictment broadly alleges that for decades, Mr. Combs abused, threatened, and coerced undisclosed and unidentified women, and he engaged in persistent and pervasive pattern of abuse towards women and other individuals. This could be interpreted as treating Mr. Combs' entire sexual history over the past 16 years as part of the alleged criminal conspiracy. The government should be required to identify its alleged victims for several reasons. Mr. Combs has no way of knowing which allegations the government is relying on for purposes of the indictment, other than victim 1, Cassie, obviously. There's no way for Mr. Combs to determine who the other unidentified alleged victims are. The number of potential alleged victims and the length of time alleged in the indictment both weigh in favor of the bill of particulars. Citing another case right here, Mr. Combs is forced to mount a defense against criminal allegations that the government does not seek to prove at trial. He is entitled to know that. Explaining where the government failed to identify which alleged claims were deemed fake, defense were hindered in preparing for their defense. So they're just saying, basically, we need to prepare for trial and we need to know the identities of all the victims. I don't think this is going to happen. The judge is going to deny this shit. Ain't no way. This trial's too big. There's too many implications. There's evidence of him fucking with witnesses already. Ain't no way they're going to put these people in danger. Ain't no way. The government is forcing him unfairly to play a guessing game, one made all more challenging by onslaught of baseless allegations that desperate plaintiffs are lodging at him in civil suits designed to exact a payoff from Mr. Combs. So they're saying it's all for money and they're all big lies. All right. Who actually believes that? I mean... I just really doubt. The lawyer that did those 120 lawsuits or whatever that had the press conference, they vetted it. They said they went from 3,000 people that contacted them to 120. That's a very large amount they cut out because they vetted it. Given the anticipated amount of discovery and the expected time required for its production, Mr. Combs will be unable to adduce the identities of the purported victims from the discovery without the assistance of the government. Mr. Combs also anticipates that the discovery will contain voluminous evidence of consensual sexual activity. Oh, he's going to say it's all consensual. There was no fucking coercion at all. Even if it were possible to ascertain the victim's identity from the discovery, and especially given the volume of anticipated discovery, it is unfair to require Mr. Combs to spend significant time trying to unearth alleged victims. Third reason, the publicity of these allegations in civil suits seriously undermine Mr. Combs' right to a fair trial. It's not the state's fault that you're a famous person. Like, that's just the way the cookie crumbles. I mean, I know famous people could be targeted, but 120 people? When we know that's not the end, we know there's going to be hundreds of people involved in this. You think hundreds of people got involved and they're all vetted? Attorneys and plaintiffs making these allegations are not bound by local rule 23.1 and can therefore make limitless and unchallenged statements to the press. Mr. Combs' denials, on the other hand, are constrained to rule 23.1 because he does not know which allegations are credited by the government and thus come with the ambit of local rule. So that's their motion for disclosing victims' names, and they're all upset, got their panties in a bunch over a leaking. Let's see what the U.S. Attorney's response is here. The court should deny the leak motion for a simple reason that the defendant fails to show the leak of any grand jury material. Without any factual basis, the leak motion seeks to suppress highly probative evidence, a video of Combs brutally physically assaulting a victim in March 2016, by claiming that it was a grand jury material leaked by government agents to CNN. But as the defendant is fully aware, the video was not in the government's possession at the time of CNN's publication, and the government has never at any point obtained the video through the grand jury process. It was probably someone at the fucking hotel, clearly, right? The defendant also complains about purported law enforcement sources leaking other alleged grand jury material to the media, and several news articles cited in his papers and set forth in the attached table. Here too, the defendant is grasping at straws. That's literally what I said. What the fuck? I swear on my life I did not read this. Because the defendant cannot show that the information in the cited articles is grand jury material, and because he cannot show that the government agents with access to grand jury material leaked the information, he cannot make the prima facie showing required for the relief he seeks. Even if any of the information in the cited articles could be considered non-public information and properly disclosed, the defendant's request for relief under local criminal rule 23.1 is mooted by the order entered by this court. Second, the court should reject the defense bill of particulars motions, not only as unnecessary but improper. The victim gag motion should be denied as an attempt to backdoor the federal rules of criminal procedure to compel the government to prematurely disclose its witness list, indeed by seeking a preemptive gag order under local criminal rule 23.1, preventing potential witnesses in the criminal case and their counsel from making extrajudicial statements. The defendant is essentially asking for either a blanket order that would apply indiscriminately to any individuals with claims against Mr. Combs and their lawyers, or for a more limited order that would require the government to identify its witnesses 6 months before trial. Yeah, it's not going to happen. 6 months before trial, and that trial date's probably probably going to get pushed back. Let's be honest. This shit ain't starting in May. This shit's going to start probably September, October, November of 2025. My honest opinion, but I could be wrong. Not only would such relief be unprecedented, but the defendant should not be permitted to use a local criminal rule as a sword to gag civil claimants, whether or not their statements would be connected to this criminal proceeding, or to evade established case law in the circuit, bride them. I mean, it's a local criminal rule. It doesn't really do shit for a federal case, right? These people are across the country. Now, this is more about the leaks. Defendant cannot show that the prosecution team was a source of any improper disclosures. Even as to information sourced vaguely to federal law enforcement or something similar, the information discussed in many of the cited articles was not only known or even principally by the prosecution team. So they're saying other people knew about this shit, not just the government. Like the government didn't leak it. For instance, the cited articles about the searches of the defense Miami house and LA house contain information that could be gleaned from the material left at those residences following the searches, including the search warrants themselves, as well as the attachments of the search warrants. The recipients of those materials, presumably individuals associated with the defendant who have no ties to the prosecution team, were free to share those materials with anyone they chose, including the defendant, members of the defense staff, and any other individuals, including the press. So there's just a lot of people that had this information. Just slam dunking on this whole leaking thing. This purported law enforcement source could be anyone who read publicly available transcripts of the bail hearings in this case, or anyone who viewed the defense counsel's various media interviews following the defendant's arrest. The information in the cited articles attributed to a Miami-based DHS officer in the aftermath of the March 2024 searches include the following: we believe that there is a disturbing history of sex trafficking. We are responding to a concrete, detailed, explicit allegations. This is not random. We didn't choose his name out of a hat. We had allegations that we're following up on. We became aware of certain allegations during the course of civil suits against Mr. Combs. You have to understand that we didn't just decide on a whim to search his homes. A federal judge has to sign off. This isn't a witch hunt. These statements need not be attributed to anyone even remotely associated with the investigation. They could have come from anyone in law enforcement with a general understanding of how search warrants are executed, who has interviewed victims and pays attention to the news. This is particularly true here, where were multiple publicly filed lawsuits detailing sexual abuse, which garnered significant media attention well before searches took place. Reviewed descriptions of videos allegedly depicting sexual acts involving the defendant obtained by the media. That source is quoted by saying they're consistent with the videos we have, and just about everything you can imagine what's happening at these parties. What? These freaky motherfuckers, man. These videos are gonna come out one day. You know that, right? That's gonna be insane. That is about the victim's gag motion should be denied. Prevent prospective witnesses and their lawyers from making extrajudicial statements. Interfere with Mr. Combs' right to a fair trial. The reality is that the victim gag motion is simply another way to get at the relief sought in the bill of particulars motion. Premature disclosure of the government's witnesses and a restriction of the government's ongoing investigation. So they think it's just they're fishing for more information that the government has, because there's more coming. Obviously, there's going to be more coming. I mean, the superseding indictment is coming. Grand jury literally heard new evidence today in court. So now they're citing other United States cases. Witness list due 7 weeks before scheduled trial. Another case where it was due approximately 3 weeks before trial. Further, the defendant does not even begin to attempt to make specific showing required for an early witness list, and fails to entirely address witness safety concerns in the case where those concerns are paramount. Literally what I thought. I was like, this motherfucker's already been accused of fucking with witnesses. This is not going to go well. That's crazy that they're saying what I'm thinking. Am I smart now suddenly? What the fuck? Do I know how trials work a little bit? This is incredible. I'm just kidding. It's probably common sense. Such an order would be even more extraordinary and beyond the purview of local rule, which it relies on. The defense suggestion that the government has authorized or directed prejudicial extrajudicial statements by counsel for civil litigants is baseless and provides no support for the relief he seeks. The government understands obligations under Local Criminal Rule 23.1. It has represented multiple times on the record and is set out above fully commits to complying with those obligations as well as the court orders. And for those reasons set forward, defense motion shall be denied. Jesus. Just got slam dunked on right there, boys. I don't see the judge granting any of those motions. So yeah, comment down below how cooked you think Diddy is, because grand jury is hearing new evidence already. Hit subscribe, join the membership. Love you guys. Peace out.